defense through Mr. Dickerson of the brief, outlining the arguments as requested by Your Honor, if I may approach that brief. My argument will closely mirror this brief. I'll try and read two. Verbose. I believe that all the cases that I will be quoting I've already provided to Your Honor. If that's not true, then I could provide them. Your Honor, I would like to start.
What cases? You didn't provide it to me.
I believe I provided all the cases I will be quoting. If there are any cases that I do quote that have not been provided to Your Honor, to Mr. Dickerson, I will do so.
All right, thank you.
I would like to start my argument with two quotes from two people who are a lot smarter than I am. First is Justice Sandra Day O'Connor. She said, "There simply is no right to force speech into the home of an unwilling listener." And Your Honor, that's from the Frisbee versus Schultz case. Second quote is from the Fourth Circuit. Your Honor, this is from a case called Thorne versus Bailey.
Is that the one that you're quoting Judge O'Connor from?
Judge O'Connor was from the Frisbee versus Schultz case, Your Honor. The next matter will be a Fourth Circuit matter. I believe I provided this one as well to the court. That's Thorne versus...
I saw the Thorne case reference.
Okay.
I haven't gotten a copy of that
I've
one
never
either.
received the Thorne case itself.
Okay.
I'm sorry, but
Okay, so I will provide that.
and that's Thorne versus...
That's Thorne versus Bailey, Your Honor. That's a Fourth Circuit matter.
Fourth Circuit?
Yes. And Your Honor, the court said in that matter...
telephone...
That's a telephone... Yes, Your Honor. That is a case that upheld a telephone harassment statute.
That's the Virginia statute?
That's a Virginia telephone harassment statute.
Right.
The court upheld that statute. It prohibited the use of the telephone to harass others. It was under the captive audience doctrine, Your Honor. In that matter, the Fourth Circuit did say, prohibiting harassment is not prohibiting speech, because harassment is not a protected speech. Harassment is not communication, although it may take the form of speech, Your Honor. I believe that is what we have here in this particular matter. In this matter, we do have the speech of Mr. Fuller. I believe we are talking about the emails that he sent, political and religious speech. He has admitted to all these emails. He's provided the emails to a copy. Whether he sent the emails or not in question, the only question is whether they are in fact protected by the First Amendment, Your Honor. And the state submits that they are not protected for a number of reasons. Your Honor, if we could look at the Snyder versus Phelps case, I believe that is the most precedential case that we have here.
Which one?
Snyder versus Phelps. That's the Westboro Baptist Church case, Your Honor.
Yes.
Your Honor, in that matter, the Supreme Court of the United States found that the Westboro Baptist Church's picketing of a military funeral was indeed protected speech, Your Honor. The facts of the case were that Westboro picketed for about 30 minutes before the funeral began on land approximately, public land, Your Honor, approximately 1,000 feet from where the funeral was held. The church alerted local authorities to the funeral protest and fully complied with all police guidance on where the picketing could be staged. Your Honor, the picketing was conducted under police supervision. The protest was not unruly. The court did state that Westboro did not shout, use profanity, and no violence occurred. Your Honor, in reaching this decision, the Supreme Court looked at the content, the form, and the context of the speech to determine whether it is indeed especially protected. Your Honor, looking at the content, they found that Westboro's signs plainly related to broad issues, interest to society at large, rather than matters of purely private concern.
I'm sorry. You can take your time.
Oh,
if you need to go over 5 o'clock a bit, I'm fine.
Okay, I can slow down a bit.
So
they looked at three...
You're quoting the section...
Correct, Your Honor.
...regarding the principles of conduct.
Correct. So the Supreme Court found that in order to determine if speech is especially protected in the First Amendment, you have to look at the content, the form, and the context of the communication of the speech, Your Honor. And the court did so in the Westboro Church case. Your Honor, in that case, they found the content of Westboro's signs plainly related to broad issues to society at large, rather than matters of purely private concern. Because the issues they highlighted, the political and moral conduct of the United States and its citizens, the fate of our nation, homosexuality in the military, and scandals in the Catholic clergy were matters of public import. Now, the court examined the context of the speech. They found the speech fairly characterized as constituting speech on a matter of public concern, because for a few reasons. The first is the signs were displayed on public land next to a public speech. The speech was not in any way contrived to insulate speech on a private matter, because there's no pre-existing relationship or conflict between Westboro and between the person whose funeral it was and the family that might suggest that the speech in public matters was intended to mask an attack on Snyder over private matter. Finally, Your Honor, the court found that it was speech at a public place, a matter of public concern, for the reason I stated earlier. It was 1,000 feet away from the funeral. It was on a public street on public lands. The picketing was conducted under police supervision. It was not unruly. There was no shouting. There was no profanity. There was no violence. There's full compliance with police guidance. It also happened about 30 minutes before the funeral even happened. Your Honor, if I take a look at, apply that analysis to this case, I just do not believe that Mr. Fuller's speech is indeed protected using that content, form, and context analysis.
Tell me before, so I can miss it, if I understand if the case ever addressed form.
It did not address form in that matter. I believe they looked at the form and the fact that it was on public street, on public lands. There wasn't seem to be a specific addressing of the form, but one would say that ever since the beginning of this country, the First Amendment, that protesting in the public square is correct form and correct form. And I would submit to the court that when someone is indeed protesting on a public land, on a public street, that is a form that would cut in the way of protected speech. So, Your Honor, if we look at this matter, I believe it's highly distinguishable from the Westboro Church case. If we look at the form of this speech, Your Honor, they're emails. They're not public signs on a public street. They are speech targeted to individual people. This lends credence to the idea that the emails are a matter of private concern, not a public concern. They're not a contribution to the free and robust exchange of ideas on public issues. They are one-sided speech directed towards a single person. I do not see how that contributes to a free and robust debate of public ideas. And I feel like there's little to no contribution to the free and robust debate when you're sending a direct targeted email to a single person. I feel like there's no debate at all in this particular matter, just harassment.
Okay, when you look carefully at the language when they're talking about one-on-one, they're talking about face-to-face. Face-to-face. Now, are these people public officials? They work in a public university and a public workplace. And so I guess if you use his analogy, if you have disfavor with Walmart, you can't stand outside of Walmart with a picket sign and talk about their labor issues with their people in there. That's a public workplace. They were working in a public workplace. They were out lobbying. They were doing things that opened up debate about House Bill 2 and what was going on with it. They were in favor of it. He wasn't. Okay. And, Your Honor, I think if you look at every one of the emails that was sent, all of that stuff had been previously published in one place or another, whether it be in a book or something that is a matter of the public domain that anybody can see. I don't think that they had a particular right of privacy here based upon their own behavior. And therefore, I would ask the court to take into serious consideration the distinction that they're drawing between the Waynesboro Church case, because they were talking about face-to-face. And I believe it's the McCullen case, or whatever, the abortion clinic case. They talked about it being face-to-face. Even the employees and the people going into the face-to-face problem. This wasn't face-to-face. Had it been face-to-face, and if he'd have been there in their office, it might have been different. They might have been captive audience because he was there with his finger in their face. They're not captive the way that he communicated with them. Thank you, sir.
Thank you very much, both of you. Well, excellently argued, and I appreciate the opportunity to be a part of this matter and to address it from both sides.
Your Honor, I'm not trying to be pushy, but do you have any idea when you might make a judgment on this particular issue so we can attempt to set a trial date if it becomes a necessity?